CBS News legal analyst Rikki Klieman joins us now for more on the Rittenhouse verdict. Rikki, good morning. Let's start. Nancy referenced these two sides here of the way people look at this. What did this come down to for the jury to find him not guilty?
The jury took their time because the jury was concerned with the judge's instructions. And when you look at the law in Wisconsin and many other places, once the defendant says, "I acted in self-defense," the burden of proof is solely on the prosecution to prove beyond a reasonable doubt that he did not act in self-defense. So at that moment in time, when he is confronted with what he says is imminent danger, that he's in fear he's going to lose his life, then is his subjective belief, "I'm going to die," is that belief reasonable? Well, the prosecution has to prove it was not reasonable. That's such a difficult burden. The jury, by the way, had the instructions. They first asked for pages 1 to 6. They kept those a long time. They wanted 12 copies. And when you look at that, that was the self-defense instruction. Then they moved to the crimes themselves. They took 3.5 days. This was a long deliberation, and they thought about each charge.
Rikki, did the verdict surprise you at all? And if not, did anything about this, about this trial surprised you the most?
The thing that surprised me the most was the moment that Kyle Rittenhouse took the stand. I am a firm believer in the years that I practiced that I did not want to put my client on the witness stand because he is then fair game for the prosecution. On the other hand, what we learned after the verdict was that they had done focus groups, and the focus groups were with the defendant testifying and without him testifying. The focus group showed the defense that it was better if he testified. Kyle Rittenhouse is the only person who says that at those moments, he actually thought he was going to die. And we have to remember how brief those moments were. The first shot is the first 4 shots of Rosenbaum, less than 1 second. The next group of 4 shots involving the person who dies, Mr. Huber, and the person who is struck in the arm, Mr. Grosskreutz, who pointed the gun in the photograph at Kyle Rittenhouse's head. So it's not only Rittenhouse's fear, it's Grosskreutz, the alleged victim's testimony, that he says that Rittenhouse didn't shoot at him until he pointed the gun at him.
What are the wider implications here beyond just the details of this particular case, what happened inside the courtroom? Do you think anything else happens right now?
Well, I do. I think that legally there is no precedent here. This case rests on its facts before this jury. But societally, people did not watch this case from beginning to end. And as a result, they continue to be polarized about gun rights, about vigilantism, and certainly about the right of self-defense.
All right, Rikki, thank you so much. Do we still have time?
I think we're.
Yeah, sorry. I really wanted to talk about the Ahmaud Arbery shooting death case. The defense has rested. Your impressions of the testimony thus far?
Well, if you look at the Ahmaud Arbery case, when you have that defendant testify, when you have one of the 3 testify, and as I say, I never like to see a defendant testify. If I'm a defense lawyer, I relish it if I'm a prosecutor. I say that he was a disaster on the witness stand. Why? Even in his direct examination, he is the aggressor. His father is the aggressor. They are going after Ahmaud Arbery, who only is running. He says, the defendant says on the witness stand, that he didn't threaten him. There was no fear as he's chasing him.
He ran away from him.
He ran away. He answers he ran away. If there was ever a defendant who was talking himself into a conviction, and perhaps the conviction of his father and their neighbor, it was this one.
Yeah, key difference is
Total
a lot of
difference.
people say was the prosecution in these 2 cases.
I think that's correct. You have a very powerful prosecutor who knows what she's doing in Georgia.
All right, Rikki, thank you so much.